can do that. All right, so Miss Computer Voice told us that the recording is in progress. Megan, are you seeing the PowerPoint again on the screen? Is it? No, I have to share it. I didn't share it yet. Again, bear with me, folks. We haven't done this in a few months now, so we're a little out of practice. Is it on now?
Yes.
Good. Okay. So welcome to the program. Our workshop is called Estate Planning Essentials in Uncertain Times. I was hoping for some time that would be able to change the title of this again, because I was hoping we'd be out of the uncertain times. We're still in them. Things are better for now. And last year at this time, I said, oh, we're finally getting out of this. And I thought for good. And probably a lot of us did. And it didn't happen that way. So I'm not making any predictions now, but I am hopeful, as I'm sure we are, that maybe we are going to finally turn the tide on the pandemic and resume real normalcy, not just temporary normalcy. But be that as it may, we're happy to have the technology to be able to make a workshop and present it to folks out there. And again, this is being recorded, so we will have a link on our website. Our website is shown on the screen there, mid-hudsonlaw.com. I'll get my little trusty pointer here, and actually I had to do it from here. Laser pointer, there we go. So there you are, mid-hudsonlaw.com. And again, that will be up in probably a few days. The early next week, it will be on the screen or on the website. So I am Rich Shapiro. I'm the partner in charge of the estate planning and elder law department at our firm. On my screen, to the bottom of my screen, is Megan Conroy, and she is a colleague in the firm, and as of March 1st will be a partner in the department. So we're very excited about that for her and for us. And we're going to teach today a little bit of estate planning and elder law, and this program runs a little over 2 hours, 2 hours, 15 minutes. It seems to run historically. And our objective today is to give you sufficient education so that you can make informed decisions for yourselves or people, in your life, whether it's parents or children or someone else who has planning needs, and some of the key concepts that you need to know to, whether you're working with us or any other attorneys or other professionals, to be able to make informed decisions. And that's really what we're trying to do today. The first two slides that you have in your packet are just some of our credentials and information about us. There's my slide, and I've been doing it long enough that I'm fortunate to achieve a few things in my career, and they're all listed there. And Megan is building her repertoire as well, and continues to do great things for our clients and for the firm. So with that background information in mind, we're going to start with what we call a surprising truth. And the real truth is that most estate plans don't work. And when we say they don't work, it doesn't mean that whatever legal documents a client has are legally incorrect necessarily at all. That's rare that is the case. So if you have a trust or a will, and it says, upon my death, I want A, B, and C to get my property, that in concept is what should be happening, right? The reality is, though, that all too often the plans that are written on paper do not, in fact, turn into reality. And the reason for that, most commonly, is the lack of connectivity between the way people own their assets and their legal documents. And the most common example is, you say, in my will, I leave property to my son John and my daughter Sally 50%, but for one reason or another, one or other of the children are joint owners of your account, your bank accounts, then that ownership will trump the will. And therefore, it doesn't matter what the will says, it matters what the beneficiary designation or joint ownership in this case happens to provide for. And people don't often understand or don't even think about the implications of that. We're going to spend a lot more time on that. But that is the probably the most fundamentally common reason that we see the disconnect between what people would have wanted to happen and what actually takes place. So ultimately, what we're looking at is how to provide for the proper control of your property. So you control it in the way you want during your lifetime. You make sure that the people, persons, or institutions who you want to have control over your affairs and your property, if you become incapacitated, are in fact appointed properly. And of course, you want to make sure that what you have goes to whom you want, when you want, the way you want after you pass away. So circling back on what I said just a moment ago, everything in estate planning is tied to the titling of your assets. And how you title your assets is going to dictate what happens to them upon your death or your incapacity. And as it's noted on this slide, the magic rule, the title of your asset will lead to a particular result, some of it which you may have wanted to happen and some of which you may not have wanted to happen. Part of our objective today is to make sure you understand the way to own your assets and how to own your assets effectively so that your ultimate objectives are in fact realized. So Megan's going to talk to us about the types of title and what the implications of all of them may be.
Right. So there are really three ways that you can own property at the time of your death, and we're going to take an in-depth look at each one of those and how it connects to estate planning overall. So you can see all three of those ways listed here. There's individual ownership, where there's just one owner titled on a particular asset or account. There's joint ownership, where there are two or even more owners as the owners of a particular asset or, again, an account. And by contract, which is really pursuant to a set of instructions. And we're going to take a close look at those. So we'll start with individual ownership, right? And so this is the Megan Conroy bank account down at Orange Bank and Trust. I'm the only owner on that bank account. So that's an example of individual ownership. We start off with this general rule that if a person owns an interest in property in their own name, so the Megan Conroy bank account, and if I lose capacity or I pass away, no one else has immediate authority to deal with that account on my behalf. So someone else has to be given authority to act on my behalf. And the way that authority is granted is typically through a court, as long as no other planning has been done. So like I said, without any other proper planning, if I have that Megan Conroy bank account and I became incapacitated, I'm unable to handle my affairs. My family, my loved ones, would have to do something called an Article 81 guardianship proceeding, which is a petition to the court, where they are asking to be appointed as the person who can now manage my finances for me because I cannot do it any longer for one reason or another. So they have to be able to demonstrate, and the court is going to verify this. It's painstaking, but it's important. The court's going to just make sure that I really don't have capacity to manage my finances any longer, and that someone else needs to be given that authority. And then from there, the court will determine who is the proper person to have that authority and to manage my finances. The unfortunate thing about a lot of the Article 81 guardianship proceedings is that they tend to be extremely costly. So you're dealing with no fewer than 4 attorneys, and all of those individuals, all those attorneys are going to be paid for by the incapacitated person. You're talking about a lot of time that goes into this, and for good reason. The court has to check that I really don't have capacity, and that's important, and I want that kind of security, but it can take a lot of time for them to make that determination. It's very intrusive because there's a lot of interviews going on. They really need to make sure that not only am I the person who truly doesn't have capacity, but now who's the appropriate person to take my place now that I can't do it anymore. my family starts to argue with one another, maybe over who is the appropriate person, just really opens the door to a lot of conflict. So it really does. It's something that is a huge undertaking. And really, in a lot of cases, it's something that can be easily avoided just through a little bit of proper planning. So that's the implication of individually owned account if I became incapacitated and I did nothing else at all.
Yeah, before we go ahead, I did mention at the outset, if people do have questions, and we do encourage you to ask questions during the program, post them in the Q&A box. That's should be on your screen, and one of us will get to you with a written answer, or we'll give the answer to the group if it's something that should be shared with everybody. Okay, sorry for that interruption. Go right ahead.
So next, we take a look at what happens to that bank account if I were to pass away. Again, I'm the only owner listed on the account, and I haven't really done much other planning. So we sort of address what happens with that account here if I've done no will, or even if I have done a will. Okay, so it's sort of the same result when you're dealing with an individually owned asset. So what happens to that asset is that now it needs to pass through a process known as probate, which is another court proceeding. That is true whether or not I have done a will. So the difference here is that if I have no will in place, it means that I have no written instruction to the court regarding who I want to be the person in charge of distributing that asset now that I'm gone. And I have no written instruction stating where I want it to go now that I've passed away. So we have a state statute that says where my assets will go if I have nothing else in writing. And in my situation, I'm not married and I have no children. So at this point, and my parents survived me. So at this point, if I were to pass away, that asset will actually go to my parents, which may be what I want, but it may not be what I want. And so that's important. If I have a will, that's the mechanism where I do tell the court who I trust to manage that asset and distribute it according to the terms of my will. And the will say where that asset should go now that I've passed away. But either way, you're looking at court involvement for that particular item. So the biggest complaints that we hear, because a lot of times we sit down with someone and we have a worksheet that they'll fill out before they meet with us, and they'll indicate in there a lot of the concerns that they have. And maybe some things are things that they've thought of before, or maybe not. And typically when they get to the line that asks about probate avoidance, everyone says, I don't want to go through probate. But when you ask them why, they're not really sure why. They just heard that it's bad and that they don't want to do it. So probate, again, is just the court process that they appoint someone who's in charge of distributing the asset, and then the asset will get distributed. And these are individually owned assets. So the real complaints about probate is the time that it takes for the court to actually get to the file, because they may have a number of other files ahead of you. And then they do an assessment. They look over all of the documents that have been submitted. And so that can take a little bit of time. And here locally, it really doesn't take that long. I would say if they're really moving fast, somewhere between 6 weeks to maybe 3 months. I've seen it go back and forth, especially after COVID. But when COVID hit, everything was put on hold. There were no files moving through the courts at all. And that was something that we could not have expected. So even the simplest of administrations or probates, those were just stuck waiting for the courts to reopen. So it's very unpredictable. There's really no way to know how long the probate process is going to take.
And
there's also, go ahead.
They say they were shut down for 3 to 4 months, I think, effectively, right?
Yes. Yep.
Yeah. Okay.
There's also additional court costs that go into probating or administering an estate. So, of course, there's attorney's fees, and you're going to need attorneys to help you prepare that paperwork and submit it to the court and represent you and represent the estate. But there's also court filing fees that go along with that. And those filing fees really go by the size of the estate at the time it's submitted to the court. So there's additional cost potentially for that. But the last one is the one that I think really tends to bother people. And that's the fact that once your estate gets submitted to the court, it becomes a public record. And so some people, that just feels very intrusive. They don't like the idea of their business being aired out in public. But really what this means is that anyone who may have an interest in your estate, whether that's an estranged family member, an old friend that thinks that they're owed something, or a creditor of your estate, now they have this opportunity to kind of see what's going on. And if it's someone who is maybe a family member, they have the opportunity to say if they're owed something right in the paperwork. It's kind of part of the process. So it really opens it up to potential discord and just onlookers looking at what it is you have and maybe the kind of family arguments that might be happening. So now we'll talk about joint tenancy or joint ownership. And again, this is where you have two or more owners on a particular asset. So here we're talking specifically about a certain kind of joint ownership, and that's joint tenancy with rights of survivorship. And what that means is that if one owner on an asset passes away, the surviving owner or owners continue on as the owners for that property. So it's really like the last man standing gets the property. This is often seen as a solution to a lot of the problems that we see with individual ownership, because it avoids court involvement. That transfer, or not even really a transfer, that ownership, it stays with that surviving owner by operation of law. There's nothing that they need to do in order to maintain that asset as an owner. So people who are looking to avoid any kind of court involvement, they think, okay, well, I'll just add this person to my account or to my house, and that way we can avoid some court involvement completely. But really, we're going to see a couple of examples in a few minutes of the problems inherent with joint tenancy. And joint ownership really can be used on almost any kind of asset. So that includes your checking, savings, investment accounts, stocks, bonds, and real estate. Where you won't see joint ownership is on retirement accounts. So like I said, ownership passes automatically by operation of law, so no court involvement is needed. And that sounds like a good reason to move ahead with joint ownership, but it should still be used strategically, because there still are a lot of problems with relying on joint ownership as your main estate plan. So we have the list of pitfalls here. The first of which is that no single owner can direct the final disposition of their share of the property. And that's because title passes automatically to the surviving owner or owners. And so what that means is that if I own a house with my brother, for example, and on the deed we're joint with rights of survivorship, I can do a will that says that I want my 50% of ownership, right? Because this is how people are thinking. I must own 50%. I want my 50% to go to my good friend Sally. Meanwhile, if I pass away first, because I own that property with my brother, joint with rights of survivorship, doesn't matter that my will says I want it to go to Sally, it's going to stay with my brother since he's the survivor. So I couldn't direct that piece of property the way I initially thought I could. Joint ownership does not avoid the need for an Article 81 guardianship proceeding if any of the owners becomes incapacitated. So again, sometimes people think this is the solution to all kinds of court involvement, but it's not necessarily. So with that example where I own the property with my brother, let's say instead of passing away, I become incapacitated. Now my brother says, you know what, it's too much to maintain without Megan's contributions. I think that we need to sell this house. We need to get rid of it. Well, he can't just simply sell that property. He can't sign those closing docs on my behalf. He can only sign for himself unless he has a court appoint himself or someone else as my guardian. So he still needs to go through that guardianship proceeding if I've done no other preparation or planning. Adding a non-spouse as an owner may result in some gift tax implications, or certainly potentially some gift tax filings. And so we're going to take a look a little bit at gift tax in a few minutes, but it's just something to be aware of, that there may be some tax implications here that you had not previously considered by adding someone who's not your own spouse. Adding another owner renders the assets available to the creditors of any one of the account owners. So this becomes very dangerous. You're opening up that asset to liability. So again, I own the house with my brother. And let's say my brother goes through a divorce or he has an accident and he gets sued. And they're going to take a look at all of his assets and they're going to say, okay, let's at least put a freeze on everything initially. And then we'll see if the creditor or the divorcing spouse has any entitlement to this asset. It doesn't matter that he owns it jointly with me. Joint ownership does not provide Medicaid protection. And again, this is another one we really want to drill down. We're going to talk about Medicaid later in the presentation, but sometimes people will call us and they'll explain to us, what assets are in their parents' names currently. And then at the tail end, they'll always say, and then there's this account, it's worth $100,000, but mom added me to it, 15 years ago. So that's not really included, right? That's not the case. Anything in mom or dad's name, anything in the Medicaid applicant's name, even if it's jointly titled, will still be counted as an asset. So we'll look at that a little bit more later on. Joint ownership often conflicts with the desires of the original owner. So I think we're going to get to see this a little bit in a case study in just a few minutes, but it comes back to not really being able to leave that asset to an intended person through another instrument like a will. And then any owner on the account has full access to 100% of the account assets at any time. So this means that if I share something with someone, and maybe it's a bank account with $100,000, at any time, that other person can go into that bank account and clean it out or take as much as they want. Doesn't matter if we've agreed between the two of us that we're each only entitled to 50%. Legally, the bank is not going to stop them and say, hey, wait a second, you can't take out more than 50,000 here, because they are a joint owner. They are allowed to take out the full amount.
So we're going to switch gears, or sort of build upon what Megan just described in the joint tenancy and the pitfalls of it, and go through a bit of a case study here that I think is very instructive of the kind of problems that Megan just described. So in our case study, we have a woman, Esther Jones, an 82-year-old Walden resident, recently widowed. She has two daughters. Sarah lives in Walden, also just a few blocks from Esther. And Kelly lives in Texas. Esther had a stroke a few years ago and uses a walker to get around. Sarah's life is in a bit of a jumble, I guess is the best way to describe it. She's physically separated from her husband, but they haven't done anything formally legally through the courts or through an attorney. So Sarah does provide some everyday or part of the week assistance to her mother, as many adult children do, taking Esther to the doctors and doing shopping with her and taking care of other errands. So what does Esther own? Well, she and her late husband, Frank, owned a house jointly, as virtually every married couple does. And the house is worth $250,000. And she and Frank owned a number of checking accounts, totaling, or bank accounts, not just checking accounts, various bank accounts, CDs, kind of situation, also totaling $250,000. So they were jointly owned between Esther and Frank. So by operation of law, as a joint ownership, she is now the sole owner. So her total estate is $500,000, not nothing, not massive, sort of typical middle class America. So Esther and Frank had executed wills back in 1992. That's the last will that they have. And it is a classic I love you, what we call an I love you will. All assets pass from the first spouse to the second spouse, and then it would be divided upon the second spouse's death between the two daughters. And if you had Esther sitting across the table from you at this time, she would confirm that her intent was that her two daughters split the estate. And the will names both daughters as co-executors. Of course, Frank's will, which said the same thing, was largely unneeded because by virtue of all the joint ownership, Esther automatically owned the properties upon Frank's death, the real estate and the bank accounts, which sounds great on its surface. But as we'll see in a minute, the fact that she avoided probate there it wasn't necessarily helpful to her in her estate planning situation. So the tale goes as follows. One snowy day, Esther and Sarah go to the bank. Esther insists on going to the bank to do her banking. She doesn't do online banking or anything like that. So she sees the teller, who she's, sees quite regularly when she goes to the bank. This teller, very nice young person, has no knowledge of Esther's family situation other than she comes in with this particular daughter, and of course knows nothing about what Esther's estate plan is all about. So the teller sees that it's difficult for Esther to get around. You got the ice, and she's using the walker, not an easy thing. So she makes what turns out to be a fateful suggestion. She says, Mrs. Jones, why don't you just add Sarah, who's taking you to the bank anyway, add Sarah to your bank accounts. That way she can handle all your banking, and you don't have to come in and deal with this nasty weather. She can take care of your bills and take all the worry off your mind. Wonderful, right? So sure enough, Esther says, hey, that sounds great, right? What a nice, helpful suggestion. Not knowing or thinking about, or certainly not understanding the legal implications of what she's about to do, she and Sarah go to the bank assistant manager and fill out the necessary paperwork. So this is when the problems begin. Not long after Sarah is added to the bank accounts, her husband files for divorce. So during the course of discovery is the legal process in litigation by which the parties can obtain information through a formal discovery process. The husband's attorney goes through Esther's or Sarah's accounts and sees that she has an interest in $250,000 worth of bank accounts at ABC Bank. Well, he says, okay, those are assets of the marital estate, and he files a restraining notice on the accounts. So Esther can't get the money out of these accounts. So she's mortified, of course, and she has to hire her own attorney because the husband's attorney refuses to release the restraining notice. He says, prove to me that that's your money. So she has to go to court, meaning Esther, and prove that. She ultimately does get the restraining notice lifted, but of course with some time and expense. So no sooner does Esther get that taken care of than unfortunately the accounts are frozen again. Turns out that not only does Sarah have her soon-to-be ex-husband after her, but she also has been spending some of her free time at the casino up in Monticello. And as often is the case, they gave her some credit there. She ended up not being particularly successful at the slot machines and ended up owing the casino money, which she couldn't pay or refused to pay. Whether she could or couldn't pay is another story. Anyway, so the casino goes to court. She doesn't have the money to hire a lawyer. She lets a default judgment be entered, and they get a judgment against her. So they go forward, the casino's attorneys, to enforce the judgment against Sarah, and lo and behold, they're able to freeze those bank accounts because Sarah's still on them. Now, in the real world, maybe Esther would have gotten advice to take her daughter off the accounts, but in our hypothetical, that did not happen. Esther, though, in this scenario, has to go to court again, get those accounts unfrozen, so on and so forth. So, of course, Esther is just horrified by what's transpired. 6 months later, she's totally worn out by these legal battles, and she sadly passes away of a heart attack. Kelly, of course, comes back for her mother's funeral, and as is often the case, we get that all the time, the kids call the lawyers and say, I'm sorry to tell you that my mom passed away. I understand you have the will. So she called Sally Smith, the attorney, and says, I'm going to be in town. Can you meet me next Wednesday? So Sally says, yes, I have some time. So Kelly goes in to meet with Sally Smith on the Wednesday of her mother's funeral. Sally reviews the will with Kelly and confirms that, yes, under your mother's will, any estate assets are to be divided evenly between you and Sarah. Sounds good so far. Well, however, Kelly soon learns that, as you now know, because the accounts were jointly owned between Esther and Sarah, Sarah is, by virtue or by operation of law, the sole legal owner of those accounts, and the will has no control over what happens to those accounts. Kelly understandably confronts her sister about the turn of events, says, Sarah, what's the deal here? You know, mom wanted us to split the assets evenly. Sarah, of course, has a different story and says, hey, Kelly, you know, the reality is mom wanted me to have those accounts. That's why she put my name on those accounts, because while you were living it up high on the hog in Texas, I was here doing all the heavy lifting, taking care of mom and her needs. Kelly says, well, I don't believe that's what mom wanted at all. She goes to the local lawyer and hires them, brings an action against Sarah to have the estate assets or the jointly owned property split between them through a turnover proceeding. And lo and behold, their relationship is permanently severed. So unfortunately, this kind of scenario happens time and time again in the real world. Maybe not these exact facts, but similar facts. In fact, this case study was based on probably now about a 5 or 6 year old case in New York called In Ray Ash out of Staten Island. Very, very similar set of facts. Happens a lot. And that's because, that's because the banker told the people to do joint tenancy. Megan, I didn't mention this to you. A couple of days ago, I got a call from someone, one of our clients, who said, the bank told us to put me on the account as a joint owner. Exactly this scenario.
Yep.
They said they could have done a power of attorney, but they recommended to do the joint ownership.
Oh my goodness, of course.
Yeah, which is absolutely astonishing in some ways. So that's a segue. We're going to talk now about the power of attorney. I'll go into this a little bit. So we much prefer to avoid this whole joint ownership situation by using in a power of attorney, at least as a bare minimum. So the problems that we described in the case study could have been avoided entirely, really, had Esther not added Sarah as a joint owner on the account, but instead appointed her as an agent under a durable power of attorney. So as noted in the second bullet point here, a properly drafted general durable power of attorney provides the named agent or multiple agents, you can have more than one at a time, with the authority to transact your business as your agent and manage all your assets without also having ownership rights to the assets. Ultimately, powers of attorney are really essential in any estate plan, but they're really especially important when we're trying to do asset preservation planning to provide for Medicaid eligibility without a full spend down. And we'll discuss that more in detail during the Medicaid section later on. But powers of attorney are so essential for that in so many contexts. Their powers of attorney, like any legal tool, have some deficiencies. As noted here, it is a list of powers. There are no specific instructions to the agent in a power of attorney. So you're relying upon the agent to act on your behalf without any specific guidance on what they are going to do. One of the other real practical problems of a power of attorney is that the instrument itself does not remove the principal's authority to act on their own behalf, which can and often is a problem if the principal is to suffer from diminished capacity and make poor financial decisions. The most common example are the senior fraud scams that are so prevalent out there. I just got a call yesterday from a guy who said his, I think, 83-year-old father just shelled out $4,000 to the scam. It wasn't the grandchild scam, which you hear a lot about, where a young man or woman will call the senior on the phone and say, grandma or grandpa, whoever answers, it's your grandson. They don't say their name, right? And they say, I just got arrested for whatever, and I'm in jail. I need $10,000 bail. But you cannot tell my parents under any circumstances. I'm embarrassed. And so the grandparent will often wire, and they'll be asked to go to like a Western Union and wire the money. So that's one problem. The one I got yesterday was only $4,000, relatively small, but in that case, it was a guy who was claiming he needed money because he supposedly was having an affair and he couldn't tell his wife, and he had some expense that he had to pay. So that was a new one that I hadn't heard before.
Yeah. I haven't heard
Regardless,
that one.
yeah. So regardless, this is one issue that a power of attorney doesn't remove authority. When we get into talking about trust, that is a better way to remove authority. Historically, there have been problems with financial institutions who have improperly and without good cause rejected the power of attorney. And while there is a court remedy for that in the old days, meaning pre-2021, the financial institution would just be ordered to honor the power of attorney without any other financial penalty. The good news now, at least, is that effective last June, under New York's new power of attorney law, third parties who reject, who do not accept the power of attorney can be subject to legal fees and other financial penalties if a court says, hey, bank, you didn't have any good reason to reject it. It met all the criteria under the statute. So not only are you going to accept the form, you're going to pay Mr. Jones's $2,500 legal fee and a court costs. So hopefully, and we really haven't seen any real pushback yet, that third parties who reject these things are going to have to think twice before they do so. So ultimately, a general durable power of attorney is an essential planning tool, and we do them in every estate plan we do of any kind. But if of itself is not sufficient, we are going to look at other tools that are really helpful to avoid some of the negative consequences that do come with the power of attorney. And we can sort of button up everything to have every document, every planning strategy in place so that all needs can be addressed. So last, we talked about the individual ownership, and of course, we spent quite a bit of time on joint ownership because it's so prevalent. The last type of title Megan will discuss is the contractual ownership.
Right, pursuant to a set of instructions. And that might sound a little bit confusing for a lot of you here on the seminar today, but you're probably already familiar with this and you really just haven't realized it. So we're going to talk about it, and I think you're going to say, oh, I have one of these. I have this already. So title by contract, we really say is the best thing to kind of have in place in one form or another, because it really gives you the ultimate amount of control over how your assets pass. If something happens to you, this gives you that kind of control. So as you take a look at some of the examples that are listed here, that's when I think you're really going to say, oh, I have some title by contract, because it's going to be your beneficiary designations for the most part. Many of you who have retirement accounts, life insurance, and even annuities, you will have already designated beneficiaries on those different assets. And that's typically the most common place you'll see them, because as you're filling out the forms to establish that policy or establish the account, part of it is, do you want to designate your beneficiaries? This is a really good moment for each of you to kind of take stock of what your assets are. And if you have any of these, you should make sure that you have beneficiaries listed on them, particularly your retirement accounts. But going through the estate planning process, this is all stuff that you should review, your attorney should review, and there's going to be some counseling that goes into that. But really make sure you have beneficiaries designated. Some people don't realize that you can designate beneficiaries on your regular bank accounts and investment accounts as well. This is going to come in the form of POD, sometimes called, which is payable on death. ITF is in trust for, but those are beneficiary designations. So if you're looking to add beneficiaries and you say, I need to designate a beneficiary, and they say, well, that's an in trust for designation, that's okay. That's a beneficiary designation. And then we kind of get to the ultimate contract, we call it, and that's going to be a trust agreement. So sometimes people will say, what is a trust? I've heard about a trust and I don't know that I necessarily understand what it is, right? And it's a contractual agreement, and it will control your assets at different periods during your lifetime, your incapacity, and certainly after death through your beneficiary designation in that contract. So we're going to discuss different kinds of trusts. And the first one that we'll take a look at is a living trust. That is one that you create during lifetime, and it really comes in two flavors. We have revocable or irrevocable. And then within those, there are many different kinds of revocable trusts and irrevocable trusts that serve different purposes. So a revocable trust allows for changes and amendments to the document freely. It's very easy to make changes, and pretty much any provision of the document can be amended, changed, customized based on changes in your life, or maybe just you start to say, you know what, I don't know why I picked that person. Maybe I should have chosen somebody else, right? So you can rethink and revamp that document. The assets that go into the revocable trust. So this is important. There's a connection between the trust agreement, which is a contract, and your assets. They would typically be retitled into the name of the trust. And those assets that go into that trust, the revocable trust particularly, they will still be considered part of your estate for estate tax purposes. We're going to talk more about estate taxes, and in many cases, that's a good thing. That's something that you want to happen. So revocable trust assets are still included in your estate. Irrevocable trusts, technically it says in the document that you have no right to change, amend, or revoke that irrevocable trust. But under New York state law and a lot of other states have a very similar provision. You actually can revoke your irrevocable trust. There's just some paperwork and that has to go with it. And typically when it's drafted correctly, there are provisions in there that allow you to change certain things in your irrevocable trust. Maybe it's trustees and maybe it's beneficiaries. The trust can be drafted so that the assets within it are still includable in your taxable estate, which again could be a good thing. For most people it is. And the irrevocable trust is the kind of trust that you need if you are seeking any kind of Medicaid protection. And we're going to talk a lot more about that towards the back end of this seminar. There are two ways to create a trust. So we just talked about the two living trusts. And like I mentioned, that's a trust that is created during your lifetime. So you've discussed it with the attorney, they prepare the document with all of the provisions that you've crafted with them, and then you sign that document into effect, and you put your assets into that trust during your lifetime. This is also sometimes known as an inter vivos trust, which means within life. Then there's a testamentary trust. And again, this is another kind of tool that you're probably more familiar with than you'll give yourself credit for. This is a trust that is created either under a will or under a living trust instrument. So it's created through another estate planning document. And the most common example that I'll give of this is if you've done maybe a will and it was way back when you had minor children, the provision for your minor children probably said, if my spouse and I pass away and our kids are still under the age of say 21, then they'll inherit the assets, but it'll be held for them in trusts. And those trusts will be managed by someone else that you've designated, the trustee. And at a certain age, you probably have provided for the assets to come out of the trust and then be distributed to the now adult children. So that's an example of a testamentary trust. So here is an illustration of what a trust could look like. This particular trust is a revocable living trust for a single individual. Like I said before, a trust is a contract. It's a stack of papers that we put in a binder to keep things organized. But this is an illustration of how those assets could flow and the different designations that you can make within your trust instrument. So the revocable trust is the most flexible of the two trusts, the living trust kinds. And the top box will say, how the assets can be managed during that person's lifetime. In this case, assuming that that person has no reason that they can't manage their own finances, the trust maker, the person who's creating the trust, will often be also the trustee, meaning the person who's now managing the assets titled in the name of the trust. And that person has also defined all of the terms and provisions for management of those assets during their lifetime. This becomes important when we get to the disability section. In the disability section of the trust, we're oftentimes going to see a disability panel, a panel of trusted people selected by the trust maker while they had capacity, preparing for the event of incapacity. So they say that this panel of people, they can come together and either by unanimous decision or by a majority vote, they can determine that I really shouldn't be the person managing the finances in the trust anymore. Maybe I'm starting to decline a little bit, and I'm starting to ask questions about those emails that come in that say King Abdu needs $20,000, or I've won some kind of lottery and I need to pay the taxes up front. And that becomes concerning to my loved ones. So they say, we really think you shouldn't be managing finances. They are on my disability panel. They can remove me as trustee. So it's a safety mechanism. They don't get to designate who my next trustee is, though. I've already said, if I can't do it, who is my successor trustee? Who's my disability trustee? And now that disabilities trustee will be appointed, and they will manage those assets within my trust. And how do they know what to do with those assets? I've designated in the trust certain provisions to say how I want my assets managed, even if I'm not the one to do it. Was I making repetitive charitable contributions? Did I make a provision in here to say, this is the quality of life that I'm used to, and I want to make sure these funds are still available so that I can still enjoy those things that I enjoy. So all the terms will be in the trust agreement. Then we get to the after death provision, where the trust starts to look a little more like a will, except for the trust does not need to go through the court process known as probate. So your trust doesn't get probated. It avoids that completely. The trust will dictate, and this is all at my direction, I've customized this. It will dictate what happens to my assets now that I've passed away. So in this example, we have that the assets are going to be divided, say 50-50 between child 1 and child 2. So now my trustee, my successor trustee, now that I'm gone, will make sure that those assets are collected. They've taken stock of everything that I have in that trust, and they will divide them up between the 2 children. Now you'll notice that there are boxes around child 1 and child 2, and that's because I'm indicating here that I'm creating some sort of testamentary trusts for those children. Maybe those children are minors, but when we do our planning, we actually don't just provide trusts for minors. We provide trusts for pretty much any beneficiary that's coming up as that next layer, right? That succession. So I think we're going to take a closer look at that in just a second here.
Right. Before you do that, just to point out about the whole important disability provisions that Megan described, that will solve the issue that we dealt with when the typically elderly person, suffers from diminished capacity and is susceptible to that widespread multi-billion-dollar elder law financial fraud that we see. So if someone gets suckered in on that grandparents or grandchild scam that I mentioned, the children can then step in and say, okay, well, maybe we now need, as members of the disability panel, to take the proverbial keys away from dad. And now we are named as successor trustees. We'll handle the finances. And so unlike the power of attorney structure where dad still has access to the account, once the disability trustees are in place and dad is no longer a trustee, he can no longer access those finances. So it's a very important protective mechanism without the whole context of going to the court in the Article 81 procedure that Megan mentioned earlier. So now we will shift to the protection continuum that Megan alluded to a moment ago.
So here we have what we call the protection continuum, and this is really relating to those testamentary trusts that I described as being created for children or any other inheriting beneficiary. So before we really get to the trusts and the protections involved there, first we should look at what it's compared against, which is an outright distribution. And by outright, what I mean is that at some point or another, the assets will go directly from the estate or from the trust to the named beneficiary, and they'll probably take those funds and deposit it into their personal bank account, or maybe it's a joint account with somebody else. So that's the outright distribution. That can happen in one lump sum after we've collected everything. It gets divided up and distributed directly to the beneficiary. Also, sometimes people will construct this to really be distributed out in either phases or stages. They feel like that helps to preserve some of the funds. So this might look like, a third of the assets will be distributed to the beneficiaries when they reach age 25, the next third at 30, and then the final third at 35. And that way, in case they were irresponsible at 25 and they blew the first 1/3, hey, it's only 1/3. They still have 2/3 to rely on. So kind of to temper their spending a little bit. You'll also see things like maybe a distribution for life events, when they graduate college or they get married or buy their first house or have a child. There will be fixed percentages or fixed amounts that can be distributed out to the person at those different times in their life. The problem with this is that once those funds are distributed out of the estate and to that individual, those funds, that inheritance is now subject to any issues that that person encounters, whether it's that they're spenders and so they're just going to blow it as soon as they get it, or maybe they're pretty good at saving, but something terrible happened and now they're being sued, or, their relationship failed and they're going through a divorce, or even down the road, they start to say, I might need some long-term care myself. And I received this fantastic inheritance, which I'm thankful for, but it's now going to disqualify me for something like a Medicaid benefit. So the problem with outright distributions really comes from the protection that you lose by pushing that money out to the individual. That's why we do trust planning, or we're typically recommending trust planning for all of your beneficiaries after you pass away. And so immediately your thoughts are probably, I don't want to create a trust for my kids because it's too restrictive. What if they're unhappy with me or unhappy with this trust structure? But like I said before, the trust itself is something that you get to customize entirely. So you can say how restrictive it is. It doesn't have to be like those trusts that you imagine for the ultra wealthy. It doesn't have to be that at all. So here on the continuum, you see towards the center, you're going to see liberal lifetime protective trust. And this is the most liberal version, the least restrictive version of the trust that you can create for your beneficiaries. What it says is that the inheritance is going to be held in a trust for their benefit, but they get to be their own trustee, so they can manage those trust funds. And there's no restriction on their ability to access or distribute or withdraw those funds out to themselves for anything they want or need. So it's just like they received an outright distribution, except for while they don't need to spend that money, that inheritance, it stays titled in the name of the trust and thereby gets all of the protections of a trust from creditors, divorcing spouses, illness if they become ill or need to qualify for any kind of government benefit. And to whatever extent that you want, you can even create some bloodline protection, which is sometimes known as sort of in-law protection, right? You want to make sure that those assets go through the generations instead of popping out to somebody else. So that's the least restrictive trust that you can create. And that's probably the most common kind that we see. Then as you move a little bit further to the right, you're going to see conservative lifetime trust. This is a trust that's slightly more restrictive, but this is appropriate where you have a concern about your beneficiary, maybe their spending or some addiction issues, or they are the bleeding heart. And as soon as they have a trust fund available to them, they will donate it to the nearest pet shelter or whatever may be. So this is a trust that you say, I don't want my beneficiary to be their own trustee because I don't think that they would be able to handle that responsibility. They wouldn't manage the funds correctly. They would just simply withdraw them and spend them unwisely. So instead, I'm going to name somebody else to serve as the trustee, and I will be able to dictate when the distributions can be made out to the beneficiary. Is it completely discretionary and up to the trustee, whatever they feel is appropriate, or do you provide further guidance? So when you provide further guidance, that becomes more like a hybrid trust. You're saying, I don't want this beneficiary to have unfettered access to the funds, but I want to give them access for certain things or under certain conditions. You can even say, I want them to have complete access to up to a certain amount, say $12,000 a year, or 10% of the trust a year. But after that, if they need any more money out of the trustee can tell them no. It's up to the trustee's discretion to see if that's appropriate or not. So that's that conservative lifetime trust. It gives you all of the creditor protection, divorce, illness, all of those things, but it also protects the funds from the beneficiary themselves. Then you'll see the special needs trust, which is also known as the supplemental needs trust. And when your trusts are drafted, even if you originally go with a liberal trust or conservative trust, you're always going to have somewhere in your document that supplemental needs trust floating in the background as an option. This is available to any beneficiary who might need to qualify for some kind of government benefit, typically based on a disability. So a good example that you're all probably familiar with is Medicaid, but it doesn't have to just be Medicaid. It can be any kind of government benefit that's resource-based. And what this means is that if your beneficiary needs to qualify for that benefit, but the inheritance that you left to them will somehow disqualify them from receiving the benefit, it puts them over the financial threshold, then their inheritance can actually be either converted from the other trusts into a supplemental needs trust, or it can go directly into the supplemental needs trust if we know they need benefits from the outset. And that trust allows them to have that inheritance, and it can be applied for them and used for anything that they want or need, but also allows them to still qualify for government benefits based on their own assets outside of the trust. The trick with this one is that under current law, that beneficiary cannot be their own trustee for the supplemental needs trust. But other than that, there's really no restrictions. It just means that the trustee can't pay for the exact same thing that the government benefit should be paying for. But otherwise, they can still get the inheritance and their benefits.
Yeah. So this slide, I think, is one of the more important in the entire presentation, because it really crystallizes the difference between what we think about as really effective planning and what is sort of lazy planning. This side of the screen on the left is in our view sort of lazy. I mean, there's no real benefit over here. This is where we get the benefit of real effective estate planning. And this is where a lot of our conversation is going to lie in doing designs for our clients. Before we move on, there was one question on the prior slide about the disability panel. And the question was how many people should be on the disability panel. It really is very client specific. Typically what you would see is you're going to have your spouse, your attending physician, who is not put in by name, but rather just by title. And that's defined as the physician who is then in custody of your medical records and handles your primary care. And additionally, if you have adult children, some or all of them will typically be on the panel as selected by the client. So if a person has a spouse, doctor, and 3 kids, they might have 5 people on the panel. It can be specified that the opinion must be unanimous, that every panel member must agree. Some clients prefer to have majority, or if they're 5, 4 out of 5, whatever is comfortable for you to make that important kind of determination. So hopefully that answers your question. If not, you can circle back with us. So we talked about the continuum. So Megan, talk about the retirement accounts, please.
Sure. So retirement accounts are dealt with a little bit differently, and probably going through life, you've already identified that retirement accounts, they're just different beasts altogether for tax purposes primarily. But one of the things that's important to recognize is that in the prior slide, we talked about creating some protections for your beneficiaries, whoever they may be, by using these subtrusts. And this becomes a sort of different conversation when we're talking about retirement accounts. Your retirement accounts, if you're the account owner, they are safe for you in a lot of ways. But an inherited retirement account is not safe for your beneficiaries from things like creditors, okay? Also, you should know that your retirement accounts cannot be funded into a trust. And when I say that, that means that they cannot be retitled into your trust, or I guess technically they probably could, but you would not want to do that. What the reason is that you are creating a huge tax implication if you retitle that account, because it's like a withdrawal of the full amount. So that's a problem that you really just don't want to deal with. So I just told you that the retirement accounts, once inherited by your beneficiaries, are not safe. They're not protected. But I can't offer you the solution of just simply put them into your trust, right? And we can create some protection. But there is actually a solution to all of this, is where I'm going. So in 2014, sorry, I was just going to tell them quickly about the court case. 2014, U.S. Supreme Court held in Clark versus Ramaker that inherited IRAs are not protected from the reach of the beneficiaries' creditors. And so that is the thing that we are trying to address. And we can do that through something different, an instrument called a retirement plan trust. And it's a different kind of trust than what we've talked about already, but the structure is very similar. So we can take a look at that structure. So here you see an illustration, and we're going to see Archie up in the left corner there. And Archie has a $1 million IRA. So that's his IRA. He's the owner. And just like any normal IRA, he will have to take required minimum distributions during his lifetime. So this is very regular, your standard IRA, something you're probably all fairly familiar with. Chances are Archie being married to Olivia, he has Olivia listed as his primary beneficiary. And again, double check your beneficiaries, please. So he has his wife listed as his primary beneficiary. And probably without any planning at all, he would have his 3 children listed as the contingent beneficiaries. But like we said, the problem with that is that we're really losing the opportunity to create protection for the IRA once it gets passed down to his children as beneficiaries. Olivia, she could roll it over if she wants to, and at that point, we're going to have some protection there. So we're not as concerned with Olivia, but we are concerned about the kids. So the solution is to create that retirement plan trust, which is a separate trust instrument, and it doesn't get funded during Archie's lifetime, but instead we use a beneficiary designation on the IRA. So we're dealing directly with the institution, and we still have Olivia as the primary, but we are naming Cooper, Peyton, and Eli's subtrusts under the retirement trust as the contingent beneficiary of the IRA. So what that means is that after Archie and Olivia have passed away, that IRA can be distributed into their subtrusts instead of directly out to their own personal names. And by distributing it to those trusts, however they may have Archie created those trusts during his lifetime, maybe Cooper has the liberal trust, Peyton has a conservative, and Eli has a hybrid trust. Okay, so he gets to say how it all is administered, but now those funds go to their trust shares instead of directly out to them, where we have a layer of protection. Under current legislation, under the Secure Act, which passed just a couple of years ago now, Cooper, Peyton, and Eli would each have to, instead of taking regular RMDs like Archie, they would each have to deplete their portion of that IRA within a 10-year period after inheriting it. So the mechanism here that would happen would be that IRA would be payable to their trust shares, and they would each get to say when they want to take funds from their portion, their inherited portion of the IRA. The funds would first make a stop in their trust, and then from there, they can say whether they want to leave the funds in the trust. Maybe they don't need the money right away and they want to keep the protection, or they can just take it right out of the trust if they wanted to. So we call these trusts, in addition to being protective, we call them accumulation trusts, because it's going to be up to the beneficiaries to make the determination, or really the trustees, I should say, to make the determination as to whether or not to allow those funds to accumulate in their trust or to withdraw those funds from their trust. The distribution from the IRA to the trusts, that's the part that has to happen in that 10-year period. And each of them will get to determine if they want to do it, all in the first year, all in the 10th year, sporadically throughout the 10 years. But once it gets to the trust, there's no 10-year period or restriction. They can figure out when they want to take it out, if ever.
Yeah, and that's an excellent description. And one of the things, obviously, if you have a troublesome beneficiary who you do not want to give the power to make withdrawals, then you're going to have an independent trustee. But whoever the trustee is will have a determination to make about primarily on an income tax consideration.
Mhm.
These kind of trusts, if they accumulate the income, which all the income, all the distribution from a traditional IRA is going to be treated as ordinary income. If the trust retains it through the year it's been paid out, the trust will be the taxpayer. And under current trust tax law, the trust will probably be taxed at a higher rate than the individual beneficiary would be. So if there aren't any risks, if the beneficiary doesn't have lawsuits or divorces or otherwise, they or whoever the trustee is probably going to make that distribution from the trust to the beneficiary in the year that it's been paid from the IRA for tax reasons. But if there is a threat, even if you're going to end up paying a higher tax rate, if you can protect the assets once the tax is paid, you can elect to keep some or all the money in the trust. So you're giving the trustee, typically the beneficiary, the right to decide for themselves how and when to take the distributions from the trust after it's been paid out from the inherited IRA. So, so we're now going to shift gears a little bit, and if I can get my thingy out of here. Got trapped. There we go. I'm now going to talk a little about some of the estate, gift, and capital gains tax issues. Before we do that, we'll give you a little bit of a poll, try to shake things up here a little bit. I'm going to launch a poll, and you can give an answer. I'll give a minute for everybody. So the question is, what percentage of estates will owe federal estate taxes for deaths in 2020? The answer is going to be the same for 2021. I just haven't updated the question. So we had a very quick answer there. So there's no penalties for right or wrong answers. It's it's like playing Wordle, right? You get to challenge your intellect for a few moments here. Do you do Wordle, Megan?
I don't, but it sounds like everyone else does.
Exactly. I haven't done it. My wife Terry does it, so I've helped her a few times, but I haven't gotten into it yet. All right, so we got 10 people have answered, so we've got a few more up. Now we're up to 12, and we've got answer in every category. So I guess it's a good list of answers that we've chosen. So we'll give you another 10 seconds. Got a few more people to answer. Okay, we'll give 5 more seconds. And if you don't answer, forever hold your peace. Okay, we're gonna stop the poll now, and I will launch the answers. So I'll share the results. So the answer, the question again was, what percentage of estates will owe federal estate taxes for deaths in 2020? 20% answered, I'm sorry, 7% of the people on the poll answered 20%. 36% chose 30%. 6 people, or 43% of the polling people, chose less than 1%. And then the remainder, 14% of you chose 10%. The actual correct answer is 30, less than 1%, which is obviously quite a bit different than 30 or 20%. And once we get into the material in the next few slides, you will see why fewer than 1% of all states, and much fewer than 1%, pay any federal estate taxes these days. And that wasn't always the case, by the way. That happened over a period of many years. When I first started doing estate planning in 1999, it would have been closer to probably 10% at least, if not higher at the time. Wow. So what is the real story with federal estate or estate and gift and capital gains taxes, both on a federal and state basis? So first of all, people ask a lot about making gifts and when they can and what the limits are and who they can make gifts to and so on and so forth. The first thing you need to know is that every person can give to anyone else, relative or non-relative, up to $16,000 in any calendar year without not only paying gift tax, but filing any paperwork for it. So the government says, we don't care if you give to each of your 4 kids and 10 grandkids, 16,000 a year. We don't want to know about it. Don't have to file anything with us, etc. We don't care. That's your free shot. So that's great. But what if you want to give someone more than 16,000? Technically, if I buy my daughter or son a car for $25,000, I'm making a gift to them and I'm giving them more than 16,000. What's going to happen with that extra, let's say $10,000? Well, probably nothing, because in addition to the annual exclusion gifts, every person has $12,060,000 of total lifetime gift exemption that they have at their disposal. So in my example, let's say I bought a car for my son for $26,000. If you can even find a car today for sale, because there's so few of them out there. So yes, 16,000 of that gift would apply to his annual exemption, assuming I haven't made any other gifts to him in 2022. The other $10,000, I would technically have to file a federal gift tax return. And what would happen is that this $12,060,000 of lifetime exemption would be reduced in my case to only $12,050,000. Now, of course, the fact that I'm married, my wife can give the 16,000 gift too, so we probably wouldn't even have to do it in that case. So hypothetically, I'm saying if I was a single person, I would just knock off 10,000. So how do I memorialize that use of my portion of my lifetime gift exemption? I memorialize that by filing a federal 709 gift tax return for the year the gift is made. Attach it to your 1040, and that's all you have to do. So we know people are making gifts to family members, often beyond the $16,000. And by the way, that doesn't include gifts of education, payments for education. Those are separate category. You can do that above your 16,000, as well as for most medical expenses for a third party. Doesn't count against your exemption. But if you're just giving your kids money or buying a car or whatever else you do, you technically have to file the gift tax return if it exceeds the annual exemption limit. Many people don't do it, and frankly, the IRS is thinly staffed, and unless you're a multi-millionaire, it's probably never going to come up. But we as lawyers have to tell you, you legally have to file the gift tax return. Whether you do it or not, that's up to you. This number is increasing. Last year, it was 11,700,000. So it is tied to inflation. Obviously, inflation historically in the last 20 years has been quite low. Now, of course, we are seeing a big uptick in inflation. So if that continues, and hopefully it doesn't, but if it does, the exemptions will grow accordingly. There is no separate New York State gift tax. I think there's only one other state in the country. I looked at it recently. It may be Connecticut that has a separate gift tax, but don't hold me to it. I came across that recently. No other state has a separate gift tax. Keep in mind, or be aware, if you didn't know it, that all this talk about your gift exemption, your 16,000, that has no implication in the Medicaid world. If you give your kid $5,000 and if you have 10 kids and gave each one $5,000, Medicaid would treat that as a $50,000 transfer. And if it's within the look back period that we're going to cover after our after this section actually, then that will create a potential Medicaid penalty for you that has nothing to do with the gift exemption. So they're two separate concepts entirely. So that's the gift tax. Let's talk about the estate tax. So the estate tax is a tax that applies upon your death, and lo and behold, we have that same $12,060,000 number. The gift tax and the estate tax are essentially the same tax. We call it the unified credit, which simply means that if I have utilized 50,000 of my lifetime exemption during my lifetime, in the example I gave previously, I now would have only 12,050,000 to be able to pass to my heirs versus 12,060,000. So it reduces by whatever I've filed on the gift tax return. If you're in that rarefied category where you have more than that amount of assets, the tax rate is effectively 40% for assets above the $12,060,000 limit. Unless the law is changed in a little bit of 2.5 years now, a little bit more than that, the current estate tax exemption law will sunset, and we'll go back to the 2017 exemption amount of 5.6 million per person with inflation built into it. So it'll be a little bit more than that. New York, unlike the gift tax rules where there is no separate New York State gift tax, there is a New York State estate tax. And it is a little bit more than half of the federal exemption in 2022. Every New Yorker can pass 6,110,000 free of New York State estate tax. So we do have a handful of estates every year where we're going to see a New York State estate tax where there is no federal tax. New York's exemption amount, like the federal, is tied to inflation. So last year it was, I think, 5,930,000. So it went up, by a little less than 200,000. So that's the gift tax rules. So I think, as you can see, based on these numbers, especially the federal exemption, why far fewer than 0.1% of all federal decedents, people dying in the U.S., have a federal estate tax imposed on their estate for that year. Going back 15 years when it was $1 million exemption, big difference. Even factoring in the factor of time, there were plenty of estates 15 years ago that had $1 million that would have been subject to estate tax. Not so much anymore. So that's the estate tax rule. So while people are concerned about it, and we provide our pending clients or people we're meeting with for an initial meeting, we send out what's called a client concerns assessment. And one of I think the very first item on the form of a list of potential concerns that people can select for themselves is the estate tax. And it ranges from, no concern to low, medium to high. And most people put estate tax as a very high concern. The reality is it's really not, for the vast majority of us, a concern at all. But we let people decide for themselves if they want to make it a concern of theirs, until we are able to debunk that in the meeting, that, yeah, you really don't have to worry about it unless you happen to hit the lottery before your death. The tax that is a much more relevant tax for pretty much all of us is the capital gains tax. And what we're hoping to get as part of our state administration is what's called the step up in cost basis. The fundamental rule here is that your heirs do not pay a tax on the gain of appreciated assets that are in your estate, so long as the asset is part of your taxable estate. And we want that to be the case, except if we're in the rarefied air of having that 12 million or so estate that would be subject to federal estate tax. The problem is, though, that many people look to avoid either Medicaid issues or possibly even concerns about estate taxes, so they give away their assets to their kids during their lifetime. If you do that, whether it's a house or appreciated stocks or mutual funds, the kids will take your carryover basis, your cost basis. So in other words, let's say you just have a simple solution, a simple case. You have a stock that you purchased years ago for $10 a share, and it's done well, and now it's worth $110 a share. If you were to transfer that stock to your children, they will have it at its current value at $110, but if they sell it anytime thereafter, and let's say they sell it for $110, they will pay tax, capital gains tax on the $100 gain per share. Roughly $30 per share of tax will be paid. If, however, they inherit it through your estate, whether it's through a trust or a probate estate, or through a beneficiary designation, they will inherit it at its date of death value. Let's use my example, the $110 a share. If they sell it for that $110 a share value, they will pay no capital gains tax. The gain is wiped out effectively. So we want to make sure when we're dealing with our clients that unless they do have a taxable estate or are likely to have a taxable estate, that we structure their plan in a way to provide for this step up in cost basis which can save, again, 30 cents on the dollar between federal and state capital gains tax rates. Very important consideration. So we're going to move ahead to, now we've talked a lot about it, the Medicaid planning. We're going to now address the ins and outs of how the Medicaid system works, why we're concerned about it, and what do we do to best take advantage of the current rules.
And before I get started on the Medicaid planning, I see that there's just a couple of questions sitting in the Q&A,
Okay.
mostly for taxes, it looks like. Let's see. So the first one is regarding life insurance, and that life insurance is included in someone's estate for determining whether or not their estate is above the tax threshold, so determining the value of the estate. So there's certain planning that can be done to remove life insurance from your taxable estate. So depending on where you are against that exemption level, you may need that planning. That kind of planning would be appropriate, and it is counted as in the value. And then the next one, it looks like the question is, are capital gains due during the year that the property is sold? So when the gain is realized, or when the original owner dies? And Rich, tell me if I'm wrong, it's when the gain is realized, so when it's liquidated. And so sometimes that will happen when the original owner dies. A lot of times people will try to avoid that, but when the original owner dies and it passes to the next beneficiary, let's say through the estate or using a beneficiary designation, those people will get a step up in cost basis. And so it doesn't really matter that they might have to liquidate it because their gain is wiped out.
Right. So answering Rob's question there is, if you, so let's say you inherit the stock, in my example, at 110, and for whatever reason you choose, if you sell it right away, there will be no tax because there's no gain. But let's say you do hold it another year or two and it goes from $110 a share to $130 a share. If you sell it at the $130 a share price, you will recognize a gain of $20 because your cost basis has been reset at the date of death value of $110,000. So you won't pay a gain from the $10 original value, you'll get the stepped up cost basis. Hopefully that answers the question. So the next follow-up question, Ed is asking, are you saying the step up in basis benefit that applies to both inherited assets of estate that may be in a trust, much like it would outside a trust? The answer is yes, as long as the trust is drafted with the appropriate language to cause estate inclusion. And we're going to discuss one of the important powers to include in a trust to do that. But probably 97% of the trusts we draft are designed to include the asset in the estate for step-up purposes. The few that wouldn't be would be like a life insurance trust, where we don't want the assets in the trust, i.e. the life insurance policy, to be part of the taxable estate. We want to keep that out of the estate. But more often than not, for the reasons we've just discussed, we do want the step-up in cost basis to apply. So those are all great questions.
Okay, so now we'll jump into Medicaid planning. And when we're talking about Medicaid planning, we're really talking about how is a person going to afford the cost of long-term care, whatever their long-term care needs or potential future need is. And the reason people are concerned with that is that as they get older, they start to realize that that cost is sizable. It's very expensive if you start to need long-term care. So they start to research some of the avenues to see how to pay for that care. And they quickly realize that your regular health insurance does not cover your long-term care costs. So the options become privately paying for their long-term care, which is fine. But if you start to crunch those numbers, you'll realize that if you need long-term care for a duration, that you'll probably spend down most of what you've earned and saved and accumulated over the course of your life on this care. And so for those people who are looking to leave assets to their children after they pass away, or even just make sure that their spouse still has something to live off of after they're gone, that is very concerning to them. Another option is long-term care insurance, and there are lots of different kinds of long-term care insurance policies. And for the most part, they are great. Every time we have someone who has long-term care insurance, we're pretty happy to see that that is a part of their plan. But oftentimes it's only a part of the plan because maybe they couldn't qualify for a benefit that really covers the full cost of the long-term care. So they'll have to privately pay or supplement some portion. So long-term care insurance is great if you can afford it and you can qualify for it. And so for those people who are starting to listen to this and maybe they're not quite at that long-term care planning stage right now might be the time to explore some of those policies. And then the other option is to have Medicaid pay for your long-term care. Sounds simple, right? Well, Medicaid is a government benefit, and there are certain financial restrictions that you need to meet before the government will pay for your long-term care. So right now, and we're going to talk about how this is going to change or potentially change. Right now, the government says we can't just pay for everybody. So you have to show a true financial need and a true medical need before we are going to be willing to pay for your care. So when we're talking about Medicaid planning, we are talking about making sure that your assets are situated in such a way that you can more easily qualify for Medicaid to pay for your care without depleting all of your assets, all of your savings. So what are those financial eligibility requirements? These numbers get updated annually. So these are your new numbers for 2022. There are limits on resources, and resources are the assets in your name, the things that you have your name on as an owner. It could be a joint owner, could be individual ownership, could also be owned in your revocable living trust. And so an individual cannot have more than total value of assets, $16,800 of the value. This number is not including the value of your primary residence typically. It's not including the value of one vehicle. And it will not include the value of your retirement accounts as long as those retirement accounts go into payout status at the time you need that care or already in payout status. But it's all other assets. It's your checking, your savings, your non-retirement investment accounts, paper stocks and bonds that you might have floating around, even cash in the safe. Technically, all of that is going into the value of this. Also, importantly, cash value of life insurance. That's something that people sometimes forget about, or they really just don't understand that it gets factored in. Cash value of life insurance is sometimes a hidden asset that kind of pushes you over that threshold. So that's something to be aware of as well. In addition to the limits on resources, and that $16,800, that's your threshold marker to determine your eligibility for Medicaid. So if you're over that number, you are not going to be eligible for Medicaid. There are also limits on income. These numbers don't really determine your eligibility for Medicaid, but it determines how much you would be expected to contribute towards the cost of your care on a monthly basis, with Medicaid being willing to pay the rest as long as you're under the $16,800 of assets. So when we talk about a non-institutionalized individual, meaning someone who's going to stay in their own home, but an aid service is going to come to them for a number of hours each week, that person is allowed to keep it's technically $934 a month, but there's a $20 differential. So it ends up being $954 per month of their own income. So if they receive more than $954 per month, any amount over that number should go towards the cost of their care. They're going to pay the aid service privately, the excess amount, and then Medicaid will pick up the rest of the bill. There is some special planning that we can do to preserve that excess income. This person who's staying home, that's considered community Medicaid. And the government really wants to encourage people to take advantage of community Medicaid. So they do make it a little bit easier to qualify for typically. And there's something called a pooled trust that can be used to preserve excess income. So I'm not going to get into details on that, but just so that you know that there's something that can be done. For an institutionalized
sorry.
individual, and that's okay. That's a person who's in a nursing home. They now need that level of skilled nursing care. They are only allowed to keep $50 per month of their income. Plus, they can keep some additional to cover premiums for Medicare and Medicaid. But really, it's going to be $50 a month of their income is all they can keep. And any additional income that they have goes to the nursing home to pay for their nursing home care. So their regular nursing home bill. And the reason I just emphasize that is that some people think that the excess income goes to the government or goes to social services or Medicaid. And that's not what happens. You're actually paying for a portion of the care that you are receiving. And that's just the excess income, and you get to keep the $50. So that is for the previous slide was really the numbers that you are facing if you are the person who's needing that care. You're the applicant, okay? But there are also restrictions if you're married and there is a community spouse or a well spouse who does not need the care. The maximum resources that your community spouse can keep is $137,400. Again, we're not counting the primary residence here, but second homes or vacation homes, those are still on the table, so don't confuse that. Also a vehicle, and then the retirement accounts, again, are not going to be counted in this number as long as they're in payout status. So this is all other assets for that community spouse. There's also a maximum amount of income that the community spouse can keep per month, and that's $3,435 each month. Now, again, there's a little bit of math that goes into this, really dependent, and all of this is really situational, right? So there's a little bit of math depending on how much income that community spouse is actually receiving on a monthly basis. If the community spouse their income alone is under the $3,435 each month. Maybe they only receive $2,000 a month between maybe Social Security and a small pension, let's say. So that's all of their income that they have. They don't quite meet the $3,435. Well, if their spouse, who is the Medicaid applicant, is receiving income over, say, $50, because that's all you can keep in a nursing home, the community spouse is allowed to pull over the nursing home spouse's income just enough to match that $3,435. So in this example, community spouse only gets $2,000 a month. Let's say nursing home spouse gets $2,000 a month. Community spouse can take $1,435 from the nursing home spouse so that she gets to at least make that $3,435 for her normal living expenses. Keep in mind, she's home still. She doesn't need additional care. So she has utilities, food, all of that, those things to pay. Now, if the community spouse, her income alone is above the $3,435, she doesn't get to pull any of the nursing home spouse's income over because she's already at the threshold, and in fact, she's exceeding it. But here, if she's in excess of these numbers, in New York, we have something called spousal refusal, which actually allows the community spouse to keep the amounts in excess of these numbers. So she won't be depleted down to the $3,435 in most cases, because she'll submit something called a spousal refusal with the Medicaid application that will allow her to keep the overage. So now we'll talk about the look back period, which is something that most people are familiar with at this point. For nursing home Medicaid, there's something called a 5-year look back period. And what this is that at the time a person submits their Medicaid application for nursing home care, they have to submit along with it 5 years worth of financial statements for the preceding 5 years up until the Medicaid application. And what Department of Social Services is looking for in those financial statements, and it's everything, they go through it with a fine-tooth comb. What they are looking for is to see if the applicant gave away any money. So these are called non-exempt transfers. And if they did that within the 5 years prior to submitting their Medicaid application, those transfers are going to be scrutinized. And what happens is if they don't fall within certain exemptions or exceptions, then those will be tallied up. And then Social Services will determine what the penalty period is based on the amount of transfers that transpired within the preceding 5 years. So they there's a formula that they use to do all of this. And what the penalty period is a period of time that social services will not pay for that individual's long-term care because they've made these transfers. They're saying, had you kept that money in your name, you could have used it and applied it towards the cost of your care. So you should pay for your own care for that period of time, whatever that value is. So that look back period was just for nursing home care. That's important. For community Medicaid, which is staying home or even going into an assisted living facility, in 2020, the New York State government actually revealed that it planned to institute a 30-month look back period rather for community Medicaid. And they were going to phase this in over time. And again, they would be looking at all non-exempt transfers that had been made for applicants that submitted their community Medicaid application on or after October 1st, the year 2020. So we saw this coming down the pike prior to the October 1st date. But what actually ended up happening was that this here is still on the books, but it never actually was implemented, mostly because of COVID, and they didn't want to make a change this drastic effective, but also because it's very difficult logistically to implement this change. So they haven't really figured out the best way to go about this. So while technically there is the possibility of a 30-month look back period for community Medicaid, where prior to this legislation, there was no look back period for community Medicaid. So the transfers could be made one day and then that person's eligible the next day. Now they said we're putting a stop to that. There should be a 30-month look back period, but we don't know how or if or when we can actually put this into effect. So what we're starting to hear now is that it's very likely that this is going to be repealed before it ever becomes effective. So this may be a non-issue, but we want you to know that technically it's still on the books.
Right. And the issue is this, that the Department of Health has concluded that it will be so challenging for them to make the kind of care decisions for people in the community about and implement all these transfer penalties for community Medicaid, which is complicated enough. They're just, I think they've told the governor's office that they just don't think it's practical and take too much manpower and cost too much money to make up for whatever savings the state's going to see in reduced benefits. So that's not really something we expect to happen any longer. In fact, as we're going to discuss on the next slide, we're sort of going in the opposite direction, making more people eligible for care than fewer.
So like Rich just alluded to, here's sort of breaking news. So in the 2022 budget, the governor proposed eliminating the resource limits entirely for long-term care Medicaid services. So those numbers that we were just reviewing together, the 16,800, and that number changes each year, now that might go away completely. And so any person with any amount of funds in their name may be able to qualify for Medicaid, and Medicaid will pay for their long-term care. The individual income limit for community Medicaid is also potentially going to be increased to the $1,482 per month. And if this gets approved by the legislature, the proposed resource test repeal, so getting rid of that resource restriction, has to then be approved by the Centers for Medicare and Medicaid Services. So this is something that we are seeing. Like we said, right now it's in the budget, but it does have a few more hoops to jump through, a few more layers to get through before it's actually going to go into effect or even become a reality.
Yeah, and the theory here is that because wealthier people own homes and they have an exemption for the house, and they have IRAs and pay status, which are technically exempt resources, there is a concern about equity, that people who rent and lower income people are the ones who end up having to spend down their assets. So that seems to be one of the justifications behind it. And also, they're just looking to provide additional, people blow through their life savings to cover their long-term care, and the state is looking to ameliorate that reality. Now, of course, there's federal funds involved, and of course, it all comes from taxpayers, and we're going to see how that all shakes out. But at least in the short term, it looks like that's the direction we're going. But until that is in place, we're going to continue planning as we always have. So in the meantime, what are we going to do?
So we're still facing that penalty period for transfers that may have happened in the preceding 5 years. We're not going to worry about at this point the potential community look back period. So we'll just talk about the 5 years for nursing home Medicaid at this moment. And like I said, there's a formula that's used to figure out what the penalty period is. And what social services will do is they'll tally up the total value of non-exempt, uncompensated transfers and made during that 5-year period prior to submitting the application. And then they divide that total amount by the average monthly cost of nursing home care as established by New York State. So there's a fixed number that they use as the divisor for this. And I think we get to take a look at those. Yeah, perfect. So these are the regional rates. This is updated. Again, this is something that gets updated every year. We are in the Northern Metropolitan, which is why that is capitalized and in red there. And so the divisor that's used, what they determine is the average monthly cost of nursing home care in our region is $13,399 per month. So they use that number and they will divide up the total transfers that were made in the last 5 years, and they'll come up with a value, an amount that the social services is going to say, technically you're eligible for Medicaid because you've submitted your application and you've showed us that you're below that 16,800, but you've made these transfers. And so we're not going to pay for your nursing home care for this period of time. And you are going to need to now figure out how to pay for that care. And with nursing homes being so expensive, and this person only having $16,800 left in their name for the eligibility purposes, they're now scrambling to figure out how are they going to pay for this care because I've made these transfers. So that's sort of the tricky part of that look back period, is actually the penalty that's imposed if you've made transfers during that period. And that's transfers to anybody. There are certain exceptions to that rule, like spouses, for instance, are one exception, and there's a number of others, but even transfers to most children, grandchildren, those are going to be held against you. Transfers to a trust, that is going to be held against you. So, you really do need to be strategic and be aware of the implications of gifting, not so much from the tax perspective, but more so because there are Medicaid implications under the current legislation. So now I mentioned trusts, and I told you earlier that the irrevocable trusts are the ones that are protected for Medicaid purposes. But irrevocable trust planning is considered proactive planning, and that's because we are still dancing around that 5-year look back. So here we see that funding an irrevocable trust, meaning transferring assets into your irrevocable trust today, what that does is it starts the clock for the 5-year look back, so that 5 years after those assets have been funded to the trust, they will be fully exempt from nursing home Medicaid. So at that time, they're off the table, even though they're still in your trust. The Department of Social Services is not going to consider them towards your 16,800 of assets or whatever the number may be at that time. The Medicaid irrevocable trust has certain rules and restrictions, which we're going to talk about here. But the first thing is that it must, it must be irrevocable. That's important. But it also must say that that trust maker, whoever creates the trust, does not have access to the principal of the assets once they are placed in the trust. And by creating that restriction on ability to access the principal, that's how we get the protection for those assets. The trust can be drafted to still allow the trust maker to receive income from the trust. So if those assets are rental units or they are invested and they're earning some kind of interest or income, the trust maker can be permitted to still receive that income, or that can be turned off if it's something that, based on our conversations, we think it's just not necessary in this case. So that's something that you can still access, but principal has to be off the table in order to protect it. We're going to come back to that. There's a little caveat to it in just a second. But one thing that I'll note is that using an irrevocable trust to protect your assets for Medicaid purposes is almost always a better choice than outright gifts, primarily for a couple of reasons. The first is that when you create your irrevocable trust, very likely you will stay on as your own trustee. So by doing that, you maintain control over those assets. And that's what we pretty much started this seminar with, is that we want you to maintain control as long as humanly possible. So you'll still be able to control the assets. The other thing is, it's better than gifting the assets to, say, your children, because you're preserving that step up in cost basis. Because if you gift those assets to your kids during your lifetime, you may be doing it to protect for Medicaid purposes, but what you're doing is you're gifting them the basis, as Rich described before, instead of allowing them to inherit the asset through your trust if you're still looking for that Medicaid protection. And by inheriting the asset, like we said, they get that step up in cost basis, which can be huge. So here we see an illustration of the irrevocable trust. Tried to distinguish it, I think, from the revocable by making it a cylinder instead of a box, but it works in a very similar way. The provisions, though, are different. So we have the trust maker, and the trust maker, it can be an individual or it can be spouses. This could be a joint trust, and that's true for most of the trusts that we've looked at today, can be a joint trust. We are going to be calculating about what gets placed into the trust, what gets retitled to the trust, because we do have those rules where you are no longer able to access the principal of the asset once it goes into the trust. So we want to make sure that the things that go in here, you feel fairly confident that you're not going to need to dip into the principal for any reason in the foreseeable future during your lifetime. Again, we're going to come back to a caveat in a minute. You can reserve the right to receive income if there's income being generated from those assets. So things like your primary residence, that's often a good thing to go ahead and put into the trust. Oftentimes you're not going to need to access the principal. It won't be generating income, but that's probably not a big deal. That's not where you are relying on your income from the start. You still get to live there. You're going to see a couple of notes in green on the left-hand side that if you sell your primary residence during your lifetime, you get a kind of capital gains tax exemption. So even by placing the house in the trust, you can still sell your house, even in the trust, and you can still get that capital gains exemption when you sell that house. So if you're looking to pick up and move or downsize, you can still sell your primary residence. There's no restriction on that. It's just the trust sells it, the proceeds go into the trust, and then you can use those proceeds for the purchase of the next place that you want to live. You also still get your property tax exemptions on your primary residence. So if you are getting the star or enhanced star or anything like that, you'll still get those property tax exemptions. Your taxes are not going to skyrocket. Now, we said already that the trusts and transfers to the trust will be subject to the 5-year look back, which is why this is proactive planning. So that's important to keep in mind, and just something that you need to be conscious of under current legislation. We'll move over to the right side where you get to see the trustees. And like I said before, and as long as there's no reason that you shouldn't be managing finances, there's no reason that you can't be your own trustee here. If it's a joint trust, maybe both spouses are the trustees. That's the most common thing you'll see. Just like we saw in the other trust, you're going to designate who your successor trustees are. So in case you lose capacity or you pass away, you already have those provisions in place. And then one thing that people kind of panic about for an irrevocable trust is that they feel like it's very inflexible. Well, in your trust, it's going to say that, let's say you designate who your successors are and you have a great list going, but over time you're starting to rethink that list. You can actually change who your successor trustees are. As long as you still have capacity, that is a provision that you can make changes to. Coming back to distribution of principal, like I said, you're not permitted to distribute principal directly from your trust to yourself. But what you do have is the ability to distribute principal out of your trust to other beneficiaries that you get to designate. So you can say, you can name your children here, or you can say descendants so that you can include children and grandchildren, but you get to pick who those people are. And so this provision can be used maybe for gifting. You have some liquid funds here in the trust and you don't want to make gifts within the 5 years of needing nursing home. So you can make transfers out of your trust to the children or grandchildren or whoever is named here. But where we really see the value in this is that you can make distributions of principal for other purposes as well, not just purely gifting, but you can distribute principal out to these beneficiaries. And at that point, technically, they can do whatever they want with it. But if you've had a conversation with them and they understand that you're distributing the principal out of the trust to them because you need to access the principal, they may turn around and give you that amount that you've distributed out to them. So it's almost building in a loophole into the trust so that you're not violating the terms of the trust, but you do have this sort of safety valve. If you needed to access just a little bit of the principal without collapsing the entire trust instrument, you could do that. So that's that mechanism here. Beneath that, you're going to see something called a limited power of appointment. This is another place where you reserve the ability to make changes. So if you have maybe children and their spouses here, you're never going to be required to make distributions out to those people. But let's say circumstances change and you want to remove the spouses, or you want to cut it down to maybe just one individual for a particular purpose. You actually can change who those lifetime beneficiaries of principal are. So that's just one area that you can actually change. Once you put this into effect and you put assets into it, the idea is that that clock is ticking. If you wanted to add assets to it later, maybe your circumstances have changed, technically you can add assets to it later, as long as you keep those assets separate from the ones that were already in the trust from the beginning or from prior. By not mixing those assets together, you will not restart the 5-year look back for the old assets, but you will start a new 5-year clock for the newly added asset. You put this in place and hopefully you're on autopilot after that. You just manage it like you always would without making the principal distributions. Should you need long-term care after the 5 years have lapsed, these assets are excluded. They're ignored completely for purposes of your Medicaid application. If you don't quite make it to the 5-year period and you do need care, at that point, it's a discussion. Can we get you through the 5-year period, or do we need to do some different planning? And there always is alternative planning if you don't quite make it through the 5 years. Just know that. Then the sort of second portion of the trust is, should you pass away, whether or not you need the care, this trust still works to distribute your assets without going through any kind of court proceeding. So there's still no probate here. We can come up with those same provisions for child 1 and child 2, those testamentary trusts that create that protection for each of the children. Keep in mind that those assets that are passing to your beneficiaries will get that step up in cost basis. So we're not worried about that anymore. We didn't gift it to them and gift the basis or anything like that. They'll get that step up in basis. And at the bottom, you'll see you reserve still, again, powers of appointment here. So if you put this trust in place and you decide that you want to change the percentages that your beneficiaries are receiving after death, or you want to change those beneficiaries completely, this is the final place where you do reserve that ability to make amendments. You can change who your beneficiaries are.
Right. And sort of answering a question that was in the Q&A, the reason this trust allows for or creates the step up in cost basis is by virtue of the reservation of the limited power of appointment. Under the current tax code, if you reserve the right to change your beneficiaries through a will or another instrument during or at the time of your passing, that is what causes the trust assets to be includable in your estate, and therefore you get the step up in cost basis. So you would not include this kind of provision in like a life insurance trust where you wanted the death benefits outside of your taxable estate. So having all these tools is great. You have to obviously know how to use them and what provisions to include to make it work for the reasons intended. So we're going to now, we've covered the real substantive piece. We're now going to talk about, in our practice, how we make all this happen for our clients. And we recommend and advocate for use of a system called the Legacy Assurance Program. We want to make sure that the plan not only works at the time we first sit down with the new client, but also throughout their life cycle, regardless of what happens in their life or changes in our world, the laws and our experiences. So we know that according to a fairly recent survey from the website caring.com, more than half, or almost 6 out of 10 American families haven't done any planning at all, other than maybe having joint bank accounts or no formal legal planning. So there's a big hole out there in the universe. For those who are looking at or considering doing planning, there are really two fundamental ways to go about it. One is the most common, is what we call the word processing type of planning versus counseling and design. Word processing can be any number of types of scenarios. Very common today with the advent of online legal services, LegalZoom being the most common. You do your own drafting essentially and your own word processing by hitting a bunch of buttons and spitting out a will. Doesn't mean your selections have any rhyme or reason to them necessarily, but that can be done. If you do go to an attorney, unfortunately, all too often, a lot of the planning we see out there is similarly word processing. The attorney has a little more knowledge and hopefully will give you some better guidance. But often the case is, we get the calls too. Someone says, I need a will. I'm going to tell you exactly how I want it to go. And they say, I want this to go to that person, that to go to this person, et cetera, et cetera. No conversation. I mean, with us, we're going to say we got to have a deeper conversation. But if it's the guy or gal who is, running to the real estate closing or handling the family court matter or whatever, and they do wills as part of everything else they do, they're probably don't have the experience or the knowledge to frankly get into the weeds of what the real underlying issues are. So let's say, okay, I can throw a will together and do that, and they'll do it, and legally it's perfectly fine, but it really hasn't given you any real value. In our world, we are counseling-based attorneys. This is all the kind of work we do. Other people in our office are doing the real estate closings and the other transactions and the family law, et cetera. That's not what Megan and I are doing. Our time is devoted to really drilling down into spending time with our clients to give them really fact-based counseling and design services for doing the planning that incorporates all the issues that we've spent the last couple hours discussing. So it's not just important to just get the planning done right on the front end. We also have to look at what happens between 2022 when you first do your planning and 2052 when you pass away, right? There are a lot of changes that are going to occur in that 30-year span. Certainly your life cycle is going to be affected by personal changes. You go from working to retirement, or changing where you live, new children, grandchildren, other scenarios. Your financial picture hopefully improves from where it is when you first did the planning. So those are the changes that you as the on the client side of the table are going to be most cognizant of that might need addressing. But there are also, of course, changes in the laws. Megan and I spent, during the course of the slides today, talking about some of the tax and Medicaid laws that have changed just in the last year. For our clients who we did planning for in 2021 or previously, if they didn't have a way to come before us in a formal way, they may not get the advantage of the new laws and the benefits that those provide. And certainly there are changes there should be changes over time in the lawyer's knowledge, experience, and ability to provide good counsel to the clients. So the reality is, though, people typically go about 20 years, 19.6 years is the statistical number, before updating their estate plans. When you think about it, it makes sense. Most people do their initial planning, not when they're dying, but typically, and not even when they get married, usually when they have that first child, sometimes the second child. So let's say they're 30 years old when they do that first will. Wife, of course, is not concerned that they have a lot of money because most 30-year-olds don't. It's really the concern who's going to be guardian for the children, right? So she drags the husband by the ear, pulls him into the lawyer's office. He couldn't wait to get out of there. The attorney just takes out the rudimentary information. Who's going to be your guardian? Okay, it's going to be, your sister Sally. She's the guardian. That's it. Will sits either in the client's, file at home, or the lawyer keeps the original in their safe, whatever the case may be. No one thinks about it again. Fast forward to age 50, you get the AARP card in the mail that you're now an eligible member, and you say, hey, lots changed. Maybe it's time to look at that will again. That's the time, 20 years. But a lot happens between age 30 and 50, and then, of course, from 50 to 70 and so on. Waiting 20 years is really not a recipe for success. The other substantial issue is that we see, when I first started doing estate planning of a serious level in 1999, I was one of the only people in this area doing trust planning as a living trust as a fundamental part of my planning. Now, many more attorneys are doing that. But even when they're being done, all too often, they are not taking care of the funding. We talked about the importance of title, and in the attorneys, in many cases, are simply setting up a living trust, whether it's revocable or irrevocable, and they're doing the deed. That's a legal act, but they're not taking care of the asset transfers and the bank accounts and figuring out the beneficiaries. And so there's a gap between the effectiveness of the documents and the outcome that we're going to get. We got to fix that. Then we have what happens when you pass away or become disabled and need to implement a disability plan, the settlement phase. So we don't want anyone to fall for what we call the magic book. We and many other attorneys now, we present our documents to our clients in these nice binders with organized tabs and everything else. But the book is not a magic book. When someone dies, somebody designated in the documents has to be given authority to act. And so we want to make sure that in our clients that there is a designated person or persons who is appointed to take responsibility for each phase of the planning, the clients during their lifetime for the design and the maintenance, but then the heirs and the designated successor trustees and executors to handle the estate when the parent dies, and to implement all the after death planning elements, whether it's handling any estate tax issues, rare of course, or more likely the getting the assets into the protective trust for the kids. Legal help is almost certainly going to be needed, and we want to make sure it's done in the most cost-effective manner. So in our legacy assurance program is really based on three key tenets. One of them is certainly we want our clients to know that we're going to provide them with good legal counsel and advice, not just take what they say and stick it on paper, but to give them real instruction about, okay, you want this person to get this in this way, maybe that's not the best way, and I'll tell you why. Ultimately, the clients are going to have the final say. It is their plan after all, but we're going to make sure it's done in an informed way, not just because that's what they thought they had to do or what their cousin told them to do. We want our clients to be participants in a formal updating program, formal being the key word there. And as we'll talk about in a few minutes, our program has an annual maintenance component that has really proven to be very effective. And lastly, we want our clients to have controlled and fully disclosed costs about what it's going to cost to administer the estate upon their passing, not some random amount that they haven't even discussed with their attorney, and otherwise their kids are going to be stuck having to make that decision and come up with that fee arrangement at a time of stress after their parent has died. So looking at the apples and oranges kind of scenario, traditional probate process, and most estates are still handled through the probate system. Most people still have wills as their primary planning tool, and therefore they're subject to the reasonable compensation rules of New York law, which are pretty much whatever the executor of the estate and the attorney agree to, whether it's on $1 an hourly amount or a flat fee or percentage. It typically falls in between 2 and 5% of the taxable estate. Under the legacy assurance program model, our fees all in for all phases will never tap between 1 and 1.5%. And we'll give you that sort of demonstration here in a minute, what we're looking at. So the traditional planning model we analogize to a teeter-totter look. So we have the upfront phase here, which traditionally is the word processing that I described earlier. Doesn't cost much or shouldn't cost much, but it tends to provide pretty low value. You're not paying, whether it's the LegalZoom or otherwise online software or the attorney you're dealing with, you're really not paying for any counseling because you're just not getting it in that context. Certainly in that planning, there's no funding traditionally done. Attorneys who don't really do this for a living aren't looking at the interplay of the legal document and the ownership of assets. And we know this because when we administer estates, there's no connection between the two. And then, of course, we have the, there's no maintenance in that kind of a plan. That's just not part of the historical structure of the standard in and out, get it done will planning structure. And then, of course, upon settlement, if the attorney keeps that will in their safe and the family comes back to the same law firm to do the settlement, they're going to say, okay, yeah, we're going to charge you 2% of your $1 million estate to administer it, and that's going to be $20,000. That's where the attorney's getting the big payoff, is on the settlement, not on the front end. But of course, you're not getting any of the value there. So it's sort of a cockeyed approach of planning in our estimation. Of course, in $1 million estate, you're probably not going to have estate tax returns filed, but the average attorney who doesn't do this work regularly doesn't do them anyway. So if they are going to be done, and sometimes even if there's no tax owed, there's the concept of portability we want to take advantage of. They're going to farm it out to typically an accountant. Good for the accountant, but the client's going to pay extra money for that. And ultimately, and most concerning to us, is that the personal planning goals that the clients would have wanted to be addressed typically aren't addressed because those questions aren't asked in the first place. Not, in our view, the ideal way of planning. So under the legacy assurance program model, we take that teeter-totter and flatten it out considerably here. Our design and counseling fee is based on a 0.5% of the taxable estate. We recognize that estate planning typically has a percentage-based element to it. So we're going to take 0.5% of that, and we're going to do a range. We're going to have a minimum fee in our practice of $5,000 for the foundational planning, and we'll cap out for the foundational planning at $18,000. Big number, but on a large estate, there's a lot of value there. Typically, we're going to do either a revocable trust or a Medicaid asset protection trust as our primary planning document. Some clients, most clients, one or the other is suitable and sufficient, but sometimes both documents are recommended, and we do an extra $1,500 regardless of which is the primary planning document. If the client has a particularly large IRA, usually when we say large, meaning $250,000 and above, we may recommend that standalone retirement trust with the Archie Manning example that we talked about, and that's a flat fee of $2,500. And that's if we're dealing with a married couple, by the way, we're not charging $2,500 a piece. We're charging one fee of $2,500, even if we're doing two separate standalone retirement trusts. So that's all the front end planning fees that we deal with. We also, of course, have to do the funding, not have to, but we insist on it because we want to make sure the plan works. We have a staff member, Sarah, her title is funding coordinator. Her job is to take the planning notes that Megan or I will put together after talking to the client about what assets are going to go in which vehicle, trusts, if there are multiple trusts, which ones, beneficiary designations. We're going to discuss that with the client to make sure it's consistent with their desires and their planning structure. We do charge $65 per funding action. So if you have pretty much all your accounts in a single brokerage account, that'll be one funding action. If you have 10 CDs in 10 different banks, that would be 10 funding actions. It does help encourage people to consolidate assets, which is usually a good thing anyway, sometimes to reduce the funding fee. But funding typically runs in our practice, our average is between $400 and $600. So you get the planning done, you get the plan funded appropriately. We then are going to ensure you have a fully maintained plan, as long as you agree to participate in it. And so our annual maintenance fee right now, it went up from $450 last year, is $475 a year for a whole slew of maintenance services. So what that does, first of all, anyone in our maintenance program, and we're pushing 400 clients in it right now, they receive access to anyone on our team, myself, Megan, our other attorney, Mavish, our 3 support team members. You can email or call us, no extra charge. That's part of your maintenance fee. So that does help encourage people, if they have a question, to contact us. They know they're not going to get a separate bill for that, and that's very helpful. Also, for those in the maintenance program, each year we have annual client education sessions, not quite as lengthy as this, usually between an hour and a half per year, where we're going to cover, okay, this year we had the new power of attorney form. And if Medicaid does away with the 5-year look back, that's something we're going to cover in this year's program once we know how that shakes out. So every client who participates, and we've historically handled those programs in person. Of course, the last couple of years they've been in this format. Going forward, I'm sure we'll do a combination of both in-person and web-based for convenience sake. And we do them throughout the year. We start usually in April and we go through November with these. So you can go in, you pick one a year and you do it. Once you attend that, you would then receive a planning review worksheet and a funding worksheet. Those are summary documents to give you a quick at a glance view of what your assets or what your current plan looks like, who your successor trustees are, who your beneficiaries are, so on. So you can easily make changes on the form and let us know what you want to change. And we'll send you your funding worksheet. So if you've acquired different assets or accounts, we want to make sure we get that owned the proper way. So that's pretty much, how we handle the maintenance and to make sure that we get everything buttoned up. And then once you send us your planning review worksheet and your funding update, we'll schedule you for an individual signing meeting. We'll update your documents as necessary and appropriate. So each year you'll have updated documents. Some documents will be updated more frequently than others, but as needed, we will get those documents updated. And that's all for the maintenance fee. So that's, and then lastly, we have the debt settlement piece. So we've gotten the planning done, we've got the funding and maintenance. We now know we can agree, and we do this with our clients on the front end. When you retain us, we will guarantee that our settlement fee to settle the estate after typically both spouses die, or if you're a single person after your death, will not exceed 1% of your estate value of your assets at the time of death. And as you'll see in our case, our actual case study in a minute here, our fee is significantly below 1% in almost every case, but that is our cap. That's the maximum we can charge. So it's important to understand that how open-ended attorney's fees are in estate settlement matters. So this is from a New York court case, and there are many cases that cite this language. This just happened to be one of them from our department. So when the court approves, typically in a probate estate, an estate settlement fee, an attorney fee, this is how they make that determination. So I'm quoting directly from the case. In determining a reasonable attorney's fee, the court should consider factors such as time and labor, difficulty of the questions involved, the amount involved. So the size of the estate is always going to be a factor in determining the fee. Counsel's experience, ability, and reputation, and the customary fee charged for such services. So the court has that broad base of making that determination. The next slide I'm going to just show you is from an actual estate's accounting. We were representing one of the beneficiaries, so we did not, we were not the law firm for the estate. So a couple relevant factors here. You'll notice the total estate value here is $867,000. Not a tiny estate, but not a massive estate. Then you'll notice the attorney took a $5,000 retainer, not unusual to get a retainer like that up front. And then when the estate was settled, he was paid another $25,015. Why that number? It's, why not exactly 30,000? Well, you'll notice the fee was equivalent to the executor's commission. Many times the attorneys will charge equal to an executor's commission which is roughly 3.4% of the first $1 million. So these numbers we're talking about are real numbers. So ultimately, what you'll see after payment of expenses, this $867,000 estate has been reduced down to below $797,000, which represents an 8% reduction in the estate value for all administration expenses. So a lot more than 1%, as you can see here. So to give you another apples to apples fee comparison, here's an actual case in our office. We had a client, lovely lady, we'll call her Rhoda Rowe for this purpose. She was 81 when she came in to do her initial planning with us. In that year, she had total assets of $1.6 million as listed there. She died 10 years later. Her assets in 2017 had grown to just over $2 million. So if she had done a traditional model plan out there, let's say she paid $650 for the will plan, will, power of attorney, healthcare proxy, and so on. Of course, there'd been no funding or maintenance in that plan because it just isn't. She hired us. Her fee was $8,000 or 0.5% of her net of her estate at the time we did the planning. She did do an additional Medicaid trust because she started with the revocable trust plan. And we actually did form an LLC, a limited liability company, for her real estate investment asset. That was another $1,000. That is not, normal for most clients. Her total funding fee came in at $750, and she paid a total of 9 years of maintenance before her death in the 10th year, which totaled $3,875. So these are actual fees that she paid. Under the traditional model, let's assume the attorney said, I'm going to charge you 2.5%. Her settlement fee on her just over $2 million estate would have been a little over $51,000. And the probate could have taken up to 6 to 12 months to finish the estate. Under our plan, based on a 1% fee cap, our total fee, we could have charged for the estate administration $20,000. What we actually charged was $9,000. And we finished the total settlement in less than 3 months without having to file anything with the court system. So comparing apples to apples, traditional model, the family was probably looking at a little over $52,000. And I can say pretty confidently that the family's personal planning goals would not have been addressed. In our structure, the total fee paid was just over $24,000, and the client's total planning goals were satisfied. There was no probate. Assets were left in protective trust for the 2 adult children who, because mom was 91 when she died, they were already in their early 60s, and the assets left to them were sheltered from a Medicaid spend down for them. So before we get to this, I know did you see there were a couple questions? Did you answer those, Megan, or you're waiting for me to pipe down here?
Well, I only saw one question come through regarding what comprises someone's taxable estate for determining our fee structure.
Okay. So the taxable estate is everything that we'd be including on a estate tax return, which is pretty much every asset you own. So this says, does this mean that retirement accounts are excluded? No, because they are not. They're part of your taxable estate. When you say tax sheltered, they're still, if you have $1 million IRA at your death, that's part of your estate, and you'd have to pay estate tax on that $1 million if you had an estate tax situation. So basically, look at what your total estate assets are. We net out, of course, mortgages and other debt. If you have a $500,000 house and a $200,000 mortgage, for our purposes, your asset is worth $300,000. So that's how we net that out. So anyhow, the last piece of the puzzle here is if people on this Zoom are interested in having meetings with us, this is how we proceed. We have a process. We're very process oriented here. So you would first schedule an initial attorney interview with us, an initial consultation. We can do it either in person or Zoom. Ordinarily, if you just call us off the street and haven't attended this webinar, we would charge you $400. We do waive that fee for people who have done the webinar. So there's a value in that, of course. If after that meeting, you decide you want to hire us, we'll talk about your planning goals and give you a preliminary plan understanding or expectation of what we think you should do. We'll give you a fee quote for it, which will be consistent with the fee structure we talked about in the last few minutes. If you decide to retain us, you'll move into the design phase. If not, you don't owe us anything. When the design meeting is scheduled, we will send out a fee agreement and you will pay half of the fee at the design for the design and half at the signing meeting, the delivery meeting we call it. At the delivery meeting, we will also do a funding meeting, and we'll combine the two, where you will sit down with Sarah and sign all your deeds and your ownership transfers and so on and so forth, beneficiary designations, all be done at the time you sign your legal documents. We also offer a family team meeting, which includes your adult children, other family members who are part of your plan that you wish to include, and we can also include your financial advisor, CPA, whoever's available. And many times we'll do that by a Zoom if people are in different parts of the country or the world for that matter. And then you're sort of on the cruise control. You'll be part of the annual maintenance. You'll get those services every year until your plan matures, and then we have to administer your estate. So that's our process and how we operate. For those people who contact us within 20 days and schedule your initial meeting, we will provide you with a complimentary copy of my book, Secure Your Legacy. There is a webinar evaluation form. You can see the link here and it's in your handout. If you go on there, we do appreciate you filling those out. But even if you don't, if you call us and want to set up a meeting, we'll be happy to do that for you as well. And that really takes us to the end. Sorry, went over by probably a couple minutes there. Yeah, 4 minutes is over the limit that I usually try to set for this. And so we appreciate your time. Certainly, if you didn't ask a question tonight and have a follow-up, you can shoot Megan or I an email. You should have our contact info. It's right on our website. While we do get some spam emails because of it, we still think it's important that people can reach out to us by email and not have to guess what our email address is or call the firm. And we do very much appreciate it. Ed, thanks for the compliments. So I was happy to have some good professional advisors on the Zoom. And this is recorded, as I said earlier. So if you want to rehear some of it and are willing to put yourself through all that time, by all means. And of course, you can fast forward to the parts you want to hear again. You don't have to hear the whole thing. So we thank you very much. Good health to everyone. And hopefully we're looking at good times ahead for the summer and for the foreseeable future. And we look forward to seeing some of you soon. So have a good evening, be safe, and take care. Bye-bye.